Hi everyone, this is Priyadashini. I will be handling CMA Inter Law classes for you. This paper consists of 100 marks, which is of descriptive type. It has both the combination of objective as well as descriptive. So through the course of time, I will be explaining you like how to approach the paper, how to approach each questions asked, how to present the paper, how to write, how to manage your time, etc. So I want you all to give 100% of your full efforts, maximum listening skill, while in this process of learning. This paper, yeah. So if you can see my screen, this paper is of 100 marks, where industrial and economic laws is 60%, which covers 60 marks of your paper. Corporate law and governance 20%, where company laws, etc. are covered, and ethics covers 20%. This ethics is the most important chapter, so that like it has only like 2 chapters to 3 chapters where you can get 20 marks out of it. So the first syllabus which is covered is industrial and economic laws. 60% of your paper consists of this. In that, we will be looking at the first topic in today's class. I want your whole attention to be put in throughout the classes. I actually wanted to meet you all in person, but then there's a pandemic situation where we go across the lockdowns and situation, but this shouldn't stop us from learning, right? So whenever you're attending law classes, keep your mind prepared, keep your mind relaxed, get to learn to understand each and every point I say. Okay, so this inter law is a very easy paper if you learn the art of writing. So my suggestion would be not only learning law, but also you should learn the practice of writing throughout the paper, throughout the session. Okay, so this course covers up to like 4 to 5 months, where you should put 100% of your efforts in law paper. Law paper is not just for passing, but I wish everyone to get exemption in this paper, and I am totally responsible for it, for you all to get exemption in this paper. Exemptions will be very, very helpful in terms of your total mark, your aggregates, your ranks. So while attending law classes, your aim should be, I should get exemption in this paper. To get exemption in that paper, you should learn the concepts thoroughly. Not only like reading it, like you should understand the concept very thoroughly, and you should put it into practice. Like you should put it into papers. You should know how to write it, how to convey it to the examiner. Okay, and also like it should make sense to you. Like if I explain you a provision, explain you different laws, it should make sense to you, like why was this law imposed, etc., right? So I need you to put full maximum attention while seeing this video. So in today's class, we'll be covering certain topics. So today itself, after watching the video, you can okay. So after watching the video, you can give a read through to my notes, which I'll be sharing after the class, and then I want you to read the CMA book the chapter which I cover. So the first one would be, I would be expecting you to read my notes so that you can understand what all I said in this video. With that, you should read CMA Inter Law book. Okay, those who have law books, you can read it, or else you can download it from website itself. You should read that book, and then after this chapter is completed, I will be giving you test worksheets, etc., so that will help you, in understanding the concepts more. Okay, I will tell you like how you should prepare, how you should start up with the topics, etc. So now let's just dive into the topic and see what is covered for today. Okay, so this is the CMA law syllabus which I told you. So yeah, you can download this from your institute website, and you can just give a go through after learning this, after watching this video, so that it makes sense. Okay, so why I am showing you superstars picture in law class? So I really wanted this to be an offline section so that I could get your points, but it is online, so that's okay. So you can tell it from your place itself. So we all know the sentence, right? Aandavan solran seiran. So I want you all to guess what is the movie of this picture and the dialogue which comes this. I'm sure like all Rajni fans or non-Rajni fans like can easily get what is this movie name. This is Arunachalam movie where it goes like Andava Solra, Arunachalam Seiram. So for all the other than who doesn't watch Collywood, you can, like, you all know, right? Superstar, who is not a fan of Superstar? So why I am bringing this movie reference today? What impact does it have in today's topic? Yeah, let me give a small gist of like few lines about this movie, a particular scene that has a wide impact or reference in this chapter. Okay, so in this movie, the hero's father, he is a multimillionaire. Okay, so he goes into a contract with his friend come lawyer, who's also a lawyer, that he has to tell his son, okay, that he has to spend 30 lakhs rupees in 30 days, or else all his assets goes to charity. He says some conditions also in that this has to be spent in only this ways, not in that ways. There will be few conditions which satisfies that. So his father, the hero's father, goes into a contract with this friend. There'll be a paper where his father signs the contract. There'll be that friend who also signs the contract. So A, B, both sign the contract and come into a agreement with each other. So after a few years, so when the friend finds his son, he says all this. So then the rest of the movie just goes like that. Okay. In this scene, while explaining the scene, I have used the term contract. I have used the term agreement. If you have listened it keenly, I use the term contract many times. I use the term agreement many times. Yes. So what impact does it have in today's class? Yes, this is what today's class is all about. Indian Contract Act 1872. Okay. So in my notes, I would be sharing this PDF with you so that you can learn that. And also I wanted to mention Indian Contract Act 1872. I think in your notes it would be mentioned as 1972. Please correct it. Years are very important. Indian Contract Act 1872. So, this Indian Contract Act of 1872 was introduced on 1st September 1872. It came into force to India in the year 1st September 1872. Okay, it is applicable to the whole of India except Jammu and Kashmir. Why? Why it is applicable to the whole of India but not to Jammu and Kashmir? Because Jammu and Kashmir has separate laws. They have separate acts. Some Indian act may cover Jammu and Kashmir, some may not. Likewise, Indian Contract Act does not cover, is not applicable for Jammu and Kashmir. Okay. So as of now, we saw 2 points. It was introduced on 1st September 1872. It is applicable to the whole of India except Jammu and Kashmir. Okay. There will be objective as well as descriptive type questions in your question paper. There will be match the following, fill in the blanks, etc. So these may be expected questions because in some laws it will be applicable to Jammu and Kashmir, in some it may not. So they may ask, there is a very high chance to ask a question like, if Indian Contract Act is applicable to Jammu and Kashmir, true or false? It's false because it doesn't cover. Okay. So to understand, so unit 1 in this chapter goes like essential elements of contract, offer and acceptance. To understand the term contract clearly, you should first understand few terms. Those terms include offer, what is offer, next, what is acceptance, agreement. The third is agreement. Okay, the first one is offer, second one is acceptance, third one is agreement. So first one is offer. What is offer? Let's take 2 person names for example, Rajini and Kamal. Okay, there are 2 persons. So Rajini offers or proposes to Kamal to paint his house for 3 lakh rupees. Okay, Kamal may accept it or reject it, but Rajini is offering 3 lakh rupees to Kamal to paint his house. This is a basic example of offer. So this is a basic example of offer. So here goes a definition which says, Section 2 of the Act defines proposal or offer as when one person signifies to another person his willingness to do or abstain from doing anything with a view to obtain the assent of the other of such act or abstinence. Okay, when one person signifies his willingness to do, like I am offering another person to do one act or abstain from doing that act. What is abstain? Not doing that act. Okay, to do one act or to not do an act. He is offering his willingness to do that or to not to do that. Okay, that is what is called as willingness to do or abstain from doing anything with a view to obtain the assent. Assent means the acceptance of the other person. He should be in a view to get the acceptance of the another person. Okay, of such act or abstinence. What is abstinence? It is a noun form of abstain. Okay, so the first definition. So all students would ask me, is it necessary to learn definition in all the chapters, all the terms? Yes, it is necessary to learn so that you will understand clearly what is being said in the law. So if you understand the definition properly, all the questions will be very easy for you to attend. Okay, so this is what the definition. And also regarding the section and the clauses, that may not be helpful for like all the terms, all the sections, all the classes, but uh, while writing descriptive questions, few of the sections, mentioning few of the sections would be helpful. Okay, so next is the characteristics. So every term in law has a definition, has their own characteristic, and their special applicability. Okay, so the second is characteristics of offer. Okay, offer must be capable of creating legal relationship. What does that mean? I cannot offer to another person to kill his friend, for example. Okay, that is not creating a legal relationship between those persons. So that is illegal, which does not qualify to be an offer. So an offer must be capable of creating a legal relationships in terms of Indian laws. Okay, then the offer must be certain. It should be doable, right? It shouldn't be like count the number of stars, count the number of sands present in the land, etc. Like offer should be certain, time bound, right? So the terms of offer should be certain. It should be doable. Offer must be different from invitation to an offer. What is an invitation to an offer? So that's a difference between offer and invitation to an offer, which is very important in terms of exam point of view also, because they may ask this like what is an offer, what is the difference between invitation to offer and offer. So invitation to offer, a classic example for this would be, I put a chair in a main road, I sit, okay, not in the main road. I put a chair in my street and I put there 500 rupees board. Okay. So you all, when the person's crossing by, may think that this is for sale. Okay. Which is an invitation to offer. I am inviting you for an offer that the chair is on sale. Okay, which is different from offer. So the invitation of offer is different from offer. Offer means I have to come to you and ask that I am offering this chair for sale. Are you willing to buy for 500 rupees? Okay. Me just sitting and putting a board like this chair is for 500 rupees, which is an invitation to offer, which may cover public to come and buy the chair, is not offer. So the difference between these two is this. So offer must be different from invitation to offer. Then the offer should be communicated clearly to the offeree. So to whom all offer is being communicated, it should be communicated clearly. For example, I have two cars with me. Okay. Let's say we take the same example of Rajini and Kamal. Rajini has two cars. One is blue car, one is red car. Okay. He is while expressing his offer, he should while expressing his offer, he should mention clearly, he should communicate clearly to which car he is willing to sell. Whether it is a blue car or it is a red car. He can't blindly say, I am willing to sell my car for 3 lakhs. That is not a clear communication, right? Rajini may think he has told a blue car, Kamal may think like he has accepted to buy the red car. There may be a difference of opinion. The state of mind would not be same. So the communication should be clear in terms of offering. Offer should be communicated clearly. Offer can be express or implied. Express means I come to you and say that this offer, I am offering you this. So Rajni goes to Kamal and says that I am offering you 3 lakh rupees to sell my car. This is an express offer. What is an implied offer? Implied means I am implying you that I am willing to make this offer. An example would be I go to a restaurant. Okay. So last week I went to a restaurant and I got idli sambar. Okay, so the waiter asked me like, what do you want? I told idli sambar, and the waiter also went, got the dish. I enjoyed my food. After that, he gives a payment bill to me, and I have to pay. Here, I did not go and offer the restaurant person, or he did not come and offer me the food. Okay, but it implies that if I go and have food in the restaurant, I have to pay the bill and come. So the offer can be expressed or implied. Okay, it can be in form of expression or it can also be implied. So offer can be conditional. This point you will be able to appreciate when I explain the characteristics of acceptance. Okay, offer can be conditional. Conditional means you will put a condition in that. So offer can be conditional. Okay, offer should be in writing or in oral. Offer can be general or specific. General means I can generally offer something to a group, to a crowd, to the public. Specific means I choose a person, I go and express my offer to him. Okay, so these are the characteristics of offer. Got it? So first one is creating legal relationship. Then the terms of offer must be certain. Offer must be different from invitation to offer. Offer must be communicated. Offer can be expressed or implied. Offer can be conditional. Conditional means I can put a condition in my offer. Offer should be in writing or in oral. Offer can be general or specific. Easy it is? Yeah. So the next topic comes lapse of offer. So in my notes, I have given just a gist. Like this is the definition, this is the characteristics, this is the offer, and I'm explaining you with an example for each and everything. It would be better if you write notes with the example in your own words so that your writing skill would be improved. And then you will be able to remember each and everything. So every time you don't need to see the recording, okay, which takes time. So one time you can see the recording and you can take notes. So after taking notes also, if you have any doubt, you can come and see the video if you want. So in your book, it will be like running through pages. All this characteristic lapse, the offer chapter alone, unit alone. Okay, so I have gisted you, jotted down the points. So this is what it is. Questions will come inside this alone. Like there may be a tricky question which can be asked in each of the every line I said, but it covers only this. Okay, so this is the characteristics, and we saw definition, then we saw characteristics. Now lapse of offer. Lapse means like it has been cancelled, there is no offer. Okay, how can offer be lapsed? Okay, so how can be offer can be lapsed? There are like points where an offer can be lapsed. This may be also a descriptive question, like mention the reasons of how offer can be lapsed. The first one is by rejection of offer. Okay, so I am the offerer. I am um, I am the offerer. I am giving an offer to another person, and that person is rejecting the offer. So it means that it is a rejection of offer. So, and also you need to learn the term offerer and offeree. Okay, so in the example of Rajini and Kamal, Rajini is the offerer who is offering 3 lakh rupees to paint this building in the first example. Yeah, an offeree is a person to whom the offer is given, which is Kamal. Okay, so offerer, offeree. So coming into this topic, lapse of offer. The first one is rejection of offer. So Kamal rejects the offer. It means that the offer is lapsed by rejection. The second one is revocation of offer by the offerer. Revocation means getting that own offer, taking away that own offer. Rajini itself is revocating the offer himself. It means revocation of offer by the offerer. So Rajini revocates his offer and keeps to himself. So revocating of offer, that can be a reason for lapse of offer by counter offer. Counter offer means I go to a shop, I ask. So we are very, very unique in bargaining, right? So I go to a shop, to a vegetable shop vendor. He says, 1 kg of apple is 100 rupees. That is an offer, right? He is offering me to give that apple for 100 rupees. I should accept that offer as it is to make that offer as valid. But I don't do that. I bargain to him, give it me for 80 rupees. Okay, then that becomes a counter offer. I am offering that person to give that apple for 80 rupees. Okay, so offer should be clearly communicated, and it can be conditional, which we saw in characteristic. Whatever offer is offered by the offerer should be accepted by the offeree. If it is not, then the offer is cancelled. If the offeree in turn makes an offer to the offerer, it makes a counter offer. Bargaining is a classic example of counter offer. Okay, they can ask in exam what is counter offer. Give an example. This may be a 2-mark question like that. Okay, so counter offer, it means example is like bargaining. That shopkeeper offered me 1 kg of apple for 100 rupees, but I cancelled that and I asked him for 80 rupees. I am offering him. So that is called as counter offer. Then lapse of time. This offer can be time bound. Rajini can give his offer to Kamal, stating that this offer is valid for like 1 month or in a reasonable period of time. But if Kamal didn't accept this offer and is like remained silent for like 3 years, it doesn't mean that this offer is getting valid for like 3 years. Okay, so lapse of time, when it crosses a particular amount of time or the mentioned amount of time, so the offer will be lapsed by lapse of time. Then failure to accept condition in conditional offer. So some offer may be conditional. Conditional in the sense I told you, right, in characteristic offer can be conditional. So I will offer you this if this happens. Okay, so this is condition. That condition should also be accepted clearly, transparently by the offeree. Okay, the failure to accept condition in conditional offer also amounts to lapse of offer. Okay, so for example, the same Rajini Kamal example, Rajini is offering his car to Kamal, but he also says, I will be offering my car for 3 lakh rupees if I had sold my bike the before week. Okay, so Rajini is saying simply, I will offer you my car if my bike is also sold in the last week. Bike is also sold in the coming week, like that. So in that he puts a condition. This offer is valid when this condition is satisfied. So but then Kamal does not accept this condition. Okay. So this leads to failure to accept condition in conditional offer, which is a lapse of an offer. Sixth is by death, insanity, or by offerer or offeree. So any one of the party dies or any of the party becomes insane, it leads to lapse of offer. So lapse of offer can be done by 6 ways. The first one is rejection, revocation, counter offer, lapse of time, by death, or by failure to accept condition in a conditional offer. So by now you should have got an idea of what is an offer mean. Offer means simply means like I am offering to another person to do something. Right? So offerer, the I am offerer, the other person to whom I'm offering the thing is called as the offeree. So the definition, characteristics and lapse of offer. Moving on to the next slide. Acceptance. So here first we should learn what is acceptance definition, what are the characteristics of acceptance, etc. So definition, it goes like section 2 clause B. When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. So in normal terms, it means I am offering to another person and he is also accepting that offer. So this creates an acceptance from that person where a promise is made. So an offer, when offered, is accepted by the other person. It's accepted by the other person, it becomes a promise. Simple? Yeah. So when a person to whom the proposal is made, Rajini Kamal, a person to whom the proposal is made, to Kamal it is made, the proposal is being made to Kamal, signifies his assent. Kamal is making the acceptance. The proposal is said to be accepted. Okay, the proposal at the time of acceptance, it becomes a promise. So a proposal when accepted becomes a promise. Got it? Yeah. So characteristics. So what are all the characteristics of acceptance? Same thing. Acceptance can be in oral or in writing. My offer can be in oral or in writing. Same way the acceptance can be in oral or in writing. It may be in expressed or implied. Same characteristics as of offer. Then, if the particular method of acceptance is prescribed, the offer must be accepted in the prescribed manner. When I am offering one person, I am asking that person to accept this through email, through a courier. That is the method of acceptance. Then, in that manner, it should be accepted. I should give my offer through mail. Okay, that is one of the characteristics of acceptance. Then, it must be unqualified and absolute and must correspond with all the terms of the offer. Unqualified, whatever the offerer tells as a makes the gives the offer, that should be accepted absolutely by the acceptor. The acceptor can reject the offer. Okay, he is applicable to do that. He can reject the offer, but when he accepts the offer, he should make it as absolute. Whatever the offerer says, he should accept it. Yes. So it must be unqualified and absolute, and must correspond with all the terms of offer. He should not say no in one condition also. He should accept everything. That is when the acceptance is made. If you want, he can reject the offer, a counter offer can be made, then the offerer can change his offer, then another offer can be made. But when one offer is made, that should be accepted by the offeree by unqualified, and it should be absolute. Okay, then conditional acceptance will amount to rejection of offer. So this point, while explaining offer, I told I will explain in this. So offer can be conditional, like I can give condition, like when this happens, this offer can be made. But acceptance should not be like that. Acceptance, the conditional acceptance will amount to rejection of offer. Okay, I cannot make a condition like I can accept this if so and so. It should be unconditional acceptance. So if there is any conditional acceptance, that will lead to rejection of offer. Then counter offer for acceptance will also amount to rejection of offer, but the counter offer may be accepted or rejected by the other party. So I told you in the example of apples. So I go to a shop to buy apples. The shopkeeper says it is 100 rupees. I reject that and I give him an offer of 80 rupees. And the shopkeeper doesn't accept it. Okay, that also leads to rejection. So that is what is also one of the characteristics of acceptance, which says a counter offer for acceptance will also amount to reject of offer. But the counter offer may be accepted or rejected by the offerer, by the other party. It must be communicated to the offerer. Since the acceptance is completed, the moment it is the communication. When my acceptance is made, it should be communicated to the offerer. When Kamal accepts Rajini's offer, he should not keep him with himself. No one knows if he is accepting the offer or not. He should tell. It should be communicated either in oral or in writing to the other person that I am accepting this offer. Mere silence on part of the offeree does not amount to acceptance. This offeree can, likewise I said, I cannot keep my mouth shut, be in silence. That cannot amount to acceptance. I should tell them that I am accepting this offer. The acceptance should be given if there is a time limit is fixed, otherwise the reasonable time. As I already told you, there should be a reasonable amount of time, or when the time is specified, that we should adhere to that time. That offeree should adhere to that time and give his acceptance. But when the time is barred, the offer lapses. Okay, so these are the characteristics of acceptance. Okay, got it? So we saw the definition of acceptance and the characteristics of acceptance. Then this is the most important topic, and most of the questions may be asked from this topic. Okay, so the topic goes like communication of offer and acceptance. Okay, so to explain this, let me open my note Bad. Okay. Yeah. Okay. So, communication of offer and acceptance. When the offer should be communicated, when the acceptance should be communicated. So, this is what the topic is. So, logically, you see, there's a person Rajni, there's a person Kamal. Okay, there's a person Rajni, there's a person Kamal. Kamal, don't mind my handwriting. Sorry, it's Rajni. Okay, this person is offering to this person 3 lakh rupees. Okay, 3 lakh rupees to paint his house. Okay, so here an offer is made. So this communication of offer will be completed when it reaches Kamal. So that is what is explained in this point. Communication of offer is complete when it comes to the knowledge of the offeree. This person is offerer. This person is offeree. So the communication of offer would be complete when it comes to the knowledge of the offeree. Okay. Example. This Rajini is in Chennai. Kamal is in Osur. Okay. Rajini puts a mail to, not mail. We can take mail means like post box mail. So courier, not mail. Don't take it as email. Take it as mail. Post office mail. So Rajini is in Chennai. Kamal is in Osur. This Rajini is putting the mail in the post box, mailbox on today. What is today's date? 1/7/2022. 1/7/2022. He is putting the mail in the mailbox today. Okay, he is offering that, like to paint my house for 3 lakh rupees. This mail reaches Kamal by 9th of January 2022. Okay, so the communication of offer will be complete when it comes to the knowledge of the Kamal. When Kamal comes to the knowledge of the offer on 9th January, Rajini may offer on 7th January, but it comes to the knowledge of the offeree only on 9th, 2 days apart. So there may be a question which is asked, can be asked, communication of offer is complete when it comes to the knowledge of the offeree. Okay, then communication of acceptance. Now Rajini says his offer to Kamal and it reaches Kamal on 9th and Kamal accepts the offer. When does his acceptance mean to like when does it communication of acceptance would be complete? That would be like two parts, as against the offerer, as against the offeree. Okay, so Rajini is the offerer, Kamal is the offeree, as against the offerer, as against the offeree. Okay, so again Kamal puts a mail to Rajini, his acceptance. He puts it on 10th Jan. Okay, Rajini's letter reaches Kamal on 9th Jan. Kamal accepts it on 10th Jan and he puts it on the same day in the mailbox. It reaches Rajini 2 days apart, 12th Jan. 12th Jan. Okay, so when the communication of acceptance is complete as against the offerer, as against the offeree, as against the offerer, when offeree puts the acceptance in the course of transmission. Okay. So you may all think that as for the offerer, the acceptance is on 12th. For the offeree, the communication of acceptance is on 10th. But it is not. But it is not. That is why I am mentioning the term against. Against the offerer, against the offerer and against the offeree. So the communication of acceptance is complete against the offerer on 10th Jan, and communication of acceptance by offeree is complete on 12th Jan. Crisscross. Got my point? As against the offerer, when offeree puts his acceptance in the course of transmission. When the offeree puts his acceptance in the course of transmission. Acceptance is complete as against the offerer. When acceptance comes to the knowledge of the offerer, as against the offeree, as against the offeree, when the acceptance comes to the knowledge of the offerer. Okay. Okay. So communication of offer and acceptance. Communication of offer is complete when it comes to the knowledge of offeree. Communication of acceptance is complete as against the offerer and offeree. Offeree. Communication of offeree is complete as against offeree is complete when the acceptance comes to the knowledge of the offerer. When his acceptance comes to the knowledge of the offerer, okay, so acceptance is complete as against offeree. When does the communication of acceptance is complete against offerer? On 10th Jan. When Kamal puts his acceptance in the mailbox and it is in course of transmission. When it is in course of transmission, acceptance is complete as against offerer. Can you get my point? Okay. Let me explain you again. Communication of offer is complete. Communication of offer, I am telling offer. Communication of offer is complete when it comes to the knowledge of Kamal, which is on 9th Jan. Communication of acceptance is it of two types, as against offerer, as against offeree. As against offerer means when Kamal accepts the offer. When is Kamal accepting the offer? And it is in course of transmission on 10th Jan. So as against offerer, it is 10th Jan. As against offeree, when it comes to the knowledge of the offerer. Okay. So when it comes to the knowledge of the offerer, which is 12th Jan. Okay. Next. Revocation of offer. Revocation of offer. Revocation means cancelling. You can ask me, why an offer? I am making the offer, then why I should cancel the offer? It may, last time changes may happen. So revocation of offer is valid in terms of offeror, in terms of offeree. So we can see what is the course of time, like when this is valid. So revocation of offer is valid before offeree puts the acceptance in course of transmission and it is out of his reach to stop it. Revocation of offer is valid. Revocation of offer. Rajini is making the offer to Kamal. He can reject, he can revoke his offer before 10th Jan. Because on 10th Jan, his acceptance goes. So before Kamal accepts it, Rajini can reject his offer. When the mail is in course of transmission, at that point, Rajini cannot revoke his offer. Rajini can only revoke his offer before 10th Jan, before Kamal accepts the offer. Okay. Then revocation of offeree, same. Before when it comes to the knowledge of Rajini, which is before 12th Jan. So revocation of offer is valid before the offeree puts the acceptance and it is in course of transmission. So revocation of acceptance is valid before the acceptance comes to the knowledge of the offerer. So revocation of offer is valid before 10th Jan. Revocation of offeree, revocation of acceptance is valid before 12th Jan. Because 12th Jan, Rajini will know that Kamal has accepted. So before 12th Jan, Kamal has to revoke the offer, revoke his acceptance. So these are the 4 points, 4 essential points. Communication of offer is complete. This is like a mantra. You should learn like a mantra. Communication of offer is complete when it comes to the knowledge of the offeree. Communication of acceptance is complete by 2 ways, as against offerer, as against offeree. Then revocation of offer is valid before the offeree puts his acceptance. Revocation of acceptance is valid before the acceptance comes to the knowledge of the offerer. Okay. So till now we saw offer, acceptance, communication of offer and acceptance. Okay. The next one is essential elements of a valid contract. Okay. So when an offer, when accepted, becomes a promise and becomes a promise, okay. And when the acceptance is done with the consideration, becomes a agreement. Okay. So agreement means every promise and every set of promises forming the consideration for each other is a agreement. Okay. First one, there should be offer. Second one, there should be acceptance. Then an agreement is made. There an agreement is made, which is of a consideration. Consideration, we'll see in detail what is consideration. For now, consideration means something of value. Because I can't accept something where no benefit is derived from it, right? So that benefit, that value is called as a consideration. So offer, acceptance with a consideration becomes an agreement, and with the enforceability of law becomes a contract. Enforceability by law, applicable by law, it becomes a contract. Okay. Example, like what is the difference? Many people, like, they use the term interchangeably, agreement, contract, agreement. Even in my example, which I gave you in the first example, that movie example, I use the term agreement in some place, I use the term contract in some place. But what is the actual difference between agreement and contract? For example, um, I am inviting you to my home for a lunch. Okay, I am offering you. You are accepting it. Okay, but then tomorrow, I am calling you tomorrow. Okay, but then you don't come to my lunch. You accept it, but then at the last minute, you didn't even inform me, but you didn't come. You didn't turn up to my home for lunch. So, I have offered you to come over my home for lunch, and you have accepted that offer that you will be coming home for lunch tomorrow. But at the last minute, you did not come. I was been waiting for you, but you did not come. So I offered, you accepted, that creates an agreement. Okay. But then, because you did not come, I cannot go and file a complaint to the police, that complaint to the law, complaint to the court that you did not come home for lunch, which is not enforceable by law, because it is you get my point, right? So when an agreement which is enforceable by law alone comes to contract, so this is what the difference. There may be, all contracts are agreement, but all agreements are not contract. All contract, to be a contract, there should be offer, acceptance, agreement, then only it becomes a contract. But all agreement need not be a contract. Okay. So we are in essential elements of a valid contract. Very, very important topic this is also. But this is a very cliche topic, so you should understand this basically to understand the further running chapters. So essential elements of a valid contract. First one, there shall be an offer or proposal by one party and acceptance of proposal by another party, which results in an agreement. This one point alone we have been learning for this much time. So there shall be an offer or proposal by one party. There should be an acceptance by another party, which results in an agreement. Okay. Second one, there should be an intention to create legal relations. In my previous example, I told you, like, I am offering another person to kill his friend, which is illegal. That doesn't qualify to be a valid contract. A valid contract should create legal relation between the person. Agreement must be supported by lawful consideration. The consideration in the agreement should be lawful. I cannot print my own money and I cannot give that money as my consideration to the other person. The parties of the contract shall be competent. Competent means I should of my whole mind, sound mind, I should offer. The other person is of his sound mind, should accept the offer. So the parties of the contract must be competent to contract. There shall be a free concern between the parties of the contract. For example, I am offering another person. We can take this Rajini example itself. I am offering, Rajini is offering Kamal 3 lakh rupees to paint his house. Okay, Kamal can reject his offer, Kamal can accept his offer. But Rajini cannot put a gun on the head of Kamal and he asks to say yes, and he asks to sign the contract. Okay, this doesn't qualify to be a free consent. Party A, which is Rajani, the offerer, he should make the offer by his own will. Party B, Kamal, who's the offeree, he should make his acceptance on his own will. There should be a free consent between the two parties. No one can compel other person. No one can make the other person to do this, do the offer as well as the acceptance. So that is what the point is. The agreement shall be, there shall be a free consent between both the parties of the contract. Okay, the object and consideration of the contract shall be legal. So it is like everywhere, like what all you do in terms of law, it should be legal, right? So the object of the contract should be legal, the consideration should be legal, the terms of consent must be certain, which is, these points we already saw in offer, characteristics of offer itself. So the agreement is capable of being performed, that is, it is not impossible of being performed. The agreement should not be, as in the case I said, to count the number of stars. That is incapable of being performed. You can't perform that. So it shouldn't be that case. So the essential elements of a valid contract is there should be an offer, there should be acceptance, which creates an agreement. The consideration should be legal. There should be the object should be legal. There should be a free consent between both the parties. Both the parties must be competent to each other. The offer must be certain. The offer must be capable of being performed. Okay. Next is Unit 2. So as of now, I guess you would be able to adapt or capture what all I have explained you throughout. Next is Unit 2, which comes void and voidable agreements. Very interesting topic. Voidable agreements. Okay, what is void? Void, difference between void and voidable in terms of English is, void is in the present tense. Voidable means in the future tense. Okay, so void means nothing, zero. So when there will be no agreement. So what is a void agreement? A void agreement, when the object of the agreement is unlawful. Okay, I go into an agreement with a person to murder or to kidnap another person. The object of the agreement is unlawful. So that makes the agreement as void. In the first place itself, it is void. Okay. So agreement without consideration. There are both persons, there is no consideration to an offer, then that is also void. There should be a consideration. But then there is a loop in this. Agreement without consideration is void unless in the past I have a debt to pay. In the past, or a time barred debt. Time barred means that time period is over and I am yet to pay the debt. So that amount, for that consideration, I am going into an agreement. That is valid because for the past payable debt, I am going into an agreement now. That is valid agreement. Then it can also be like, in writing itself I have given, or it is registered in law that I will be performing this act to such persons. In writing itself it is available, which is legally accepted. Then there can be agreements without consideration. So usually there shouldn't be any agreement without consideration. So if there is any agreement without consideration, it becomes void. Void means the agreement doesn't exist. But then, except few cases which I mentioned, time bar debt, which is in writing or registered, a promise to compensate something done. Okay, that one. Then okay, so we are seeing void agreements. In that we saw consideration and objects are unlawful when the agreement is without consideration. An agreement in restraint of marriage. No two majors can restrain, no other can restrain their marriage. So agreement in restraint of marriage is a void agreement. Then agreement in restraint of trade. I can't stop another person from doing trade in India. I can do whatever trade I want, which should be legal. So whenever there is a restraint in trade, that agreement is void in the first place. Void means it is not applicable. It doesn't exist. The agreement doesn't exist. If I go into an agreement with another person in restraining his trade, that agreement is void. Agreement in restraint of legal proceeding. Okay. Then agreement void for uncertainty. I am going into an agreement to a person stating that I will give you sum of 2000 rupees when it rains today on a bright sunny day, which is uncertain, of uncertainty. Or else I am going into a agreement with another person saying that I will give you 2000 rupees if tsunami occurs, which is uncertain. Everything are uncertain, right? So that kind of agreements are void. So void agreement means um, um, which is unlawful. The object and the consideration is unlawful. It means void agreement without consideration. Agreement in restraint of marriage, agreement in restraint of trade, agreement which is uncertain, which is not legal. Everything is void. What is voidable agreement? Voidable agreement means at first it was valid. First it was a valid agreement, but then it became void. Example. Example would be Rajni. Okay, he by writing, okay, he gave his offer to Kamal, stating that I would sell my car for 3 lakh rupees. He also mentioned the blue car for 3 lakh rupees. Rajini is of the view that he has written 3 lakh, but he has missed 1 zero in that. So there is 30,000 in that paper. But Rajini is of the view that he is offering to sell his car for 3 lakhs. Kamal is also of the view that he is buying that car for 3 lakhs. Nobody saw that missing zero. So at first there was a valid agreement between them, because he is of the view that he is selling the car for 3 lakhs to Kamal. Kamal is of the view that he is buying the car for 3 lakhs from Rajini. But then Kamal noted that after 2 months, okay, after 2 months, Kamal noted that like that 30,000 is mentioned, and at that point it becomes voidable agreement. It means it was valid at the beginning, in future it became void. It means voidable agreement. Okay, we will see in detail about void and voidable, the features, the characteristics of these agreement also. But for now, So voidable means this is what you, voidable means this example should come in your mind so that you can relate with it to understand the definition of it. Okay, next, consideration. Okay, so let us quickly understand what is consideration. Okay, consideration means, I told you at the beginning, it is of something of value, and I would explain in detail in this unit what is consideration. So goes by the definition, which says consideration. This definition is like a tongue twister, so it will be fun to learn this definition. Consideration, as and when at the desire of the promisor, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such act or abstinence or promise is called as consideration for promise. I know that you might have not understood anything from this, but let me explain you in detail. It says consideration as when at the desire of the promisor. Every time the consideration should go at the desire of the promisor. Only Rajini can tell his consideration for his offer. Kamal has no point here. Only Rajini, the offerer, can, the promisor, can tell his consideration. Okay, like so at the desire of the promisor, the promisee or any other person has done or abstained from doing. So as I told you, like offer can be made to do, the willingness to do or not to do. So that is what they say. The consideration can be for doing an act or to not do an act. Okay, this is the definition, which means something of value. That value need not only be in monetary terms but in other terms also. Types of consideration: future, present, past. Okay, like consideration, like in future, I'm giving a consideration for an act which is done in future. I'm giving consideration for act which is act which is done in the present. I am giving a consideration where an act is done in the past. So where an act is done in future, where an act is done in present, where an act is done in past. Doing that act or not doing the act, both that can be. So that goes with types of consideration. Then characteristics. So what are the characteristics of a consideration? So as you can see this, legal rules regarding consideration. The first one, it must move at the desire of the promisor. I told you, always the promisor only has to tell his consideration. It may move from promisee or any other person. That consideration could be to promisee or any other person. So Rajini, his giving consideration to Kamal. He can give to Kamal or for example, excuse me. So it may move from promisee or any other person. For example, Kamal has to pay a debt to Raju. Have you seen Big Boss? Big Boss Raju. Yeah, in that. So we'll take that Raju. So Kamal, Rajini has accepted to give a consideration to Kamal, 3 lakh rupees, where Kamal has to pay that 3 lakh to Raju. He has a debt with Raju, okay, Kamal. So this Kamal can ask Rajini to pay 3 lakh directly to Raju. So this is what, it may move from promisee or any other person. Consideration may be something of value. It may be an act, abstinence or forbearance or a written promise. That consideration, as I told you, need not only be the monetary benefit. Monetary benefit means money benefit. That should not be the only case. It can be an act, it can be not doing an act, it can be a promise, etc. It may be past, present, and future. It must be lawful. Consideration need not be adequate. What does it mean? I need not pay 3 lakh sum of rupees to Kamal. The agreement can go like, I can give you 5 rupees also, but there should be some consideration, but that need not be adequate. Okay, for example, consideration need not be adequate. So in this, I am selling a plot of land. Okay, in that plot, per square feet is 3,200, which is of lawful standard. But I am selling it for 1,200 only. The consideration is not adequate, but there is some consideration which is inadequate. So that is also is possible. So consideration need not be adequate. It must not be illusionary. Like there should be some consideration. Must not be opposed to public policy, etc. So these are the rules regarding consideration. Like we saw the definition, the types, the features of consideration. So for a contract, there should be a offer, there should be a acceptance which creates an agreement when enforceable by law gives a contract. So by this you can learn the definition of contract. Yeah, the contract as an agreement enforceable by law. So it's just one single term. To understand that one single term, you should learn what is offer, what is acceptance, what is consideration, what is agreement, what is enforceability by law. Then comes the contract. So the contract means an agreement which is enforceable by law. Okay. So next is stranger to contract. So stranger to contract, it is important topic and most asked question in exams. It may come or may not come, but every year this question you can see doctrine of privity of contract in your question paper. So stranger, what does it mean, doctrine of privity of contract? Privity means privacy. So what does this section say? It means that no stranger of a contract can sue the contract. It means when there is both the parties in a contract, only that both parties can involve in that contract, can take legal action in that contract, can sue that contract, sue the other parties to the contract, but no third party can sue upon it. Only Rajini and Kamal is responsible for the contract. No third party can come and sue the contract. That is called as doctrine of privity of contract. Like no third person has a right to do anything in that contract. Okay, so you can just read the lines like what is doctrine of privity of contract, which I gave, and there are exception in these cases which we'll be learning. So first for 2 minutes just read what is doctrine of privity of contract. Yeah, the contract is between the parties and no third person can sue upon it. Sue means to put case, to put a complaint. Okay, so only a person who is a party of a contract can sue upon it. In India, this is applicable also. So, yeah, what are the exceptions of it? Let's see it. Beneficiaries under trust or charge. I have a trust. Okay, I am a member of a trust, and there are few other people who's also the member of a trust, but the trust is going into a contract with another party. In that, I am a just a member, right? So I am a third party to that contract, because the trust and the other person is only going into a contract. But here, even I have the right, because even I am a third party who's just a member of a trust, I have the right to sue because I am a beneficiary in that trust. What all contract, what all actions taken by the trust will affect me. So I am a third party of that contract, but also I can sue them. I am responsible. I have the right. So beneficiaries of under trust, marriage settlement. When there is a settlement between both the in marriages, there can be a invergence of third party, acknowledgement or estoffel. Estoffel, I will explain you in the next slide. Agency, assignee in case of insurance policy. So when uh, we'll give nominee, assignee while creating a bank account or insurance policy, right? So these are exemptions of stranger to a contract. Okay. Then legality of the object or consideration. You all know that there should be uh, the object must be legal. It should not be forbidden by law. Any provisions of law, there should not be any fraud, any injury to person or property. It should be in par with public policy. So the legality of the object is it should be legally accepted in the court of law. Okay, e-contracts. This is like a small chapter. They may ask you, actually this question came in 2018, I guess, to explain the features of e-contracts. Features of e-contract means it is paperless. It means that like we would be writing in paper, but nowadays e-contracts are more applicable because it is paperless, it is electronic, it is fast. Yeah, there no needs to be a signature. There can be a digital signature. It is very speed, fast, accurate, reliable also. Okay, so these are e-contract. E-contract means same, there will be offer, there will be an acceptor, but there won't be a paper. It will be in through system, through a software system. Okay. So here it also mentions e-contracts also requires basic elements of a contract. Okay. Then capacity of a contract, like who all persons can go into a contract. All person can go into a contract, but there are exceptions. A minor cannot go. A person of unsound mind means he doesn't have the sense to understand the terms of the contract. So the person who is of unsound mind, the person who is disqualified in some law, so he has committed a murder, so he is disqualified in by the law, so those persons are not capable of entering into a contract. So a minor, a person of unsound mind, a person disqualified from any other law, so these are the person who is not competent in entering into a contract. Other than that, any other person is applicable to enter into a contract. Okay, so here comes minor. In this we will see like what all the minor is responsible for, what are the position of minor's agreement. There shouldn't be any a minor shouldn't enter into a contract, right? A minor shouldn't enter into a contract, but then we'll see like what all is the minor's uh, characteristics to enter into the agreement, what all the few topics. It is an interesting topic also. So the first one is minor. So who is a minor? The person who has not attained the age of 18 years. Okay, 18 years of age, he is a minor. And if that minor person has a guardian, that age is 21 years. Okay, so you can read this. As per section 3, every person in India is a minor if he has not attained the age of 18 years. However, in case of minor whose person or property or both the guardian has been appointed under Guardians and Wards Act and whose property is under the superintendence in any court of wards before he attains 18 years of age is 21 years of age. So that minor has a property, he is also has a guardian. That minor has a guardian. So that property will go to the minor on attaining his majority, not at the age of 18 but at the age of 21 years. In law, like they won't ask you a question like easy simple questions like what age is for a minor to become a major. They will ask this in a property, like in a Guardian and Wards Act, whose property is under the superintendence of a ward. So what age he has to attain to get those property. It's so while seeing these questions, minor, major, we all would strike 18 years. But then this is important. Guardian and Wards Act, the property should be given to the minor at the age of, even he is attending the major at 18 years, but if he is appointed a guardian, the property is applicable will be given to him only at the age of 21 years. Okay, so position of a minor. When I enter into an agreement to a minor, what is the position of the minor? In the minor's point of view, we are looking into this topic. Agreement with a minor is void ab initio. This is a Latin term which means the not applicable at initial stage itself. Ab initio means at first itself it is void. So when I enter into an agreement with a minor, that agreement is void at the first itself. So here comes the law of estoppel does not apply against minor. Okay. The law of estoppel does not apply against a minor. Law of estoppel means who does not have the right to argue. Estoppel means does not have the right to argue. For example, that principle excludes a person who is saying something in contrary to something which he has said before. So there is some criminal, okay. He has said something before the court, like, yeah, I have only committed the crime. So like that he has given his statement. After that, after some time, he is not given the right to argue again. He is not given a chance to argue again, stating to make his point, any other point. That is law of estoppel. So the definition goes by principle which excludes a person from asserting something contrary to what is implied before. So that is called as law of estoppel. This law is not applicable to minor. He can. So before he can say one thing, after that he can say other things. It is applicable. So we should be careful with minors, right? The small persons here. Small children. So it means a minor can always plead his minority despite earlier misrepresenting to be a major. For example, I am a minor, but I don't look so. But then let's keep as an example, I am a minor. I am below 18 years of age, but I am going into a contract with another person stating that I am a major. Okay, but when the other person finds out and we go to a court, I can plead my minority. I can say that, sorry sir, without knowing that I did like this. So I can plead my majority. So at first I said when I am a major, now I am saying that I am not a major. So this law of estoppel does not apply to minor. In other words, he cannot be held liable on an agreement on the ground that since earlier he had asserted that he had attained majority, that I am not responsible for anything. I am not responsible for any liability. Okay. Then, doctrine of restitution. I guess law of estoppel is understood by everyone. Like, so yes, right? Okay, so if you have any further doubts, you can just come into a live session with me so I can explain to you more on this. Okay, so but then like this is what it is. Like law of estoppel means I don't have the right to argue, don't have given the right to say anything in contrary which I have said before, but this does not apply to a minor. He can plead his minority. Now, doctrine of restitution does not apply against a minor. Doctrine of restitution means doctrine of restitution does not apply against a minor. For example, a person has shoplifted something from a shop, like he has thefted something from a shop. Okay, so knowing that the shop owner has beaten him as like a pulp, he has turned purple beating him because he has done a crime of thefting. Okay, so the court of law says is applicable, like the doctrine of restitution is applicable here, where means the shopkeeper has to spend for that person's medical expenses, or the shoplifter, that person who has performed the theft, has to give back everything which he has stolen. This is what is called as doctrine of restitution. Okay, like the shoplifter has to pay the sum of rupees which he has stolen, or the shopkeeper has to go that person's medical expenses. Okay, this is what is called as doctrine of restitution. This does not apply to a minor. If a minor goes and goes into an agreement and he is not liable to do anything, if he is in this situation also, he is not applicable to give anything from his end to the other person. So doctrine of restitution does not applies to minor. No ratification on attaining majority. It means so the next point goes like no ratification on attaining majority. Ratification means acceptance or telling that I have attained my major. I don't need to say that. No ratification on attaining majority. Then contract beneficial to minor. So all the contracts he can, this minor can be an agent for a contract. Okay, so in that contract can be beneficial only to him. So the next point comes as minor as an agent. Minor can be appointed as an agent, but he is not personally liable for this act. Like two persons can enter into a contract. In that, he can be an agent to one person. Like he can be a be in that contract, but he is not responsible for any of the act which those two persons take. Then minor's liability for necessity. If someone has supplied a minor or his dependents with necessities, minor's property is liable, but the minor cannot be personally liable. It means I am supplying some necessities to a minor. Okay. So he has to repay me back, right? That repayment cannot be personal. It can only be liable to the minor's property. Got it? The next is minor cannot be adjudged insolvent. Like he cannot be termed as an insolvent because he is a minor. Where a minor and an adult jointly enter an agreement with another person, the minor is not liable and the contract can be enforced against the major person. This I told you already, like when two persons enter into a contract and in one-sided party there is a minor and a major person, other sided party is a major person, only that two major person is responsible for all the acts and liabilities. The minor cannot be responsible. The minor is he is not liable for anything for his act which is done for an agreement. Okay. So here we learned many new words: void ab initio, law of estoppel, doctrine of restitution, ratification, etc. Okay, so the minor is should not go enter into a contract. And what are the other person who is not applicable to enter into a contract? So they are alien enemy. So any other country. So any other country's enemy. If for example India is in not good terms with any other country and we go into a contract with that country's person, then that is a disqualified person. Foreign sovereign and ambassadors, convicts means a person who does illegal things. Insolvent means he has gone okay, let me explain what is insolvent. I cannot pay my debt in future. I have got a debt more than my assets. I cannot pay it further. So at that point of time, the court announces me as insolvent. Okay, insolvent means I have got debt like for 5 lakh rupees, but my assets are worth only for 3 lakh rupees. All the cash I have and all the money I have, only 3 lakh rupees. So only 3 lakh rupees I'll be able to pay. The 2 lakh rupees I am not able to pay. It means insolvent. Whatever happens, I will not be able to pay. It's not that I cannot pay, I will not be able to pay because I don't have anything. So that is called as insolvent. So with that person you can't enter into a contract. Then company or statutory bodies. Okay, so these are the disqualified persons from a contract. Okay, so I have covered a few topics which you should be revising again today itself. Whenever you are seeing this video, listen my video, read the handout which I give, and also read the same topics from your book, from your institute material also. Okay, I will also be sending few homeworks and exercises in this chapter to you. You should write that in a paper and submit it to me in the next class. So it will reach you out to mail or whatever. So these topics, so if you have any doubt, let's connect in a live session so you can throw me what all doubts you have. I can explain it to you. Yeah. So these notes I'll be sharing to you, homework notes I'll be sharing to you. Yeah, that's it for today's session. So this is how the class goes in each um, topics which is covered. So next video I'll be covering the same chapter but different topics which you need, which is very important in exam perspective. So you be ready, you be thorough with what all I have explained to you today, and you'll be ready so that you can understand the other topics which I explained in future months. So in 2 classes, one chapter will be over, Indian Contract Act will be over. I guess in 2 classes it might be over, or it may take 3 classes. So so that's it for today's topic. So I request you to learn all the topics by today itself, put it in your mind, then while going to sleep just revise the topics. You can just see this notes itself, so these are just jotted down so simply, and morning you can again revise the topics which I explained. Then this topic will be stored in your mind, and then by the week end you can again start revising the chapters. Or so when I explain it to you now, you grasp the topic, and then when you revise it for 2 times, and then again when you see it for the next month or while re-revising it, it will be very, very easy for you. Take it from me. This is how I used to prepare for my exams also. So it's just a small tip. Here and there, I may be giving you some tips so you can just follow it. So you just follow. Yeah. Meet you in the next session. Hopefully it should be like offline classes so that I can interact with you in person, but then it's fine. You just take care. Happy New Year everyone. Bye.